Yeah, let me know when you guys want me to.
You want to get started then? Okay, yeah, go ahead.
Hi everyone, thank you so much for being here. It's a great event and I hope you guys have all enjoyed meeting speakers and speaking with other women and just thank you guys for joining us. My name is Daniela. I am a co-chair for the Latinx Law Student Association and we're proudly co-sponsoring this wonderful panel here. And if you are a practicing attorney, here are some papers to receive MCLE credit. So please come up whenever you can, maybe afterwards, just to make it easier. So yeah, I'll be happy to introduce our wonderful panel. First we have Professor Hasen. He is an internationally recognized expert in election law and campaign finance regulation. Also in writing as well as in areas of legislation and statutory interpretations, remedies, and torts. He is a co-author of leading casebooks in election law and remedies. Professor Hasen also served in 2020 as a CNN election law analyst. He directs UCLA Law's Safeguarding Democracy Project and earned his JD from UCLA Law, and we're very lucky to have him here. Next up is Sonni Waknin. She is a program manager at the UCLA Voting Rights Project and Voting Rights Council. She's currently co-counsel on Soto Palmer v. Hobbs and Portugal v. Franklin County, two federal lawsuits defending voting rights. She also recently defended the constitutionality of the Washington Voting Rights Act from a legal challenge. Sonni has wanted to be a voting rights since she was in high school. Previously, she interned with the ACLU Voting Rights Project and for Common Cause National Redistricting Project. She is also a UCLA alumna and also was in the PIL program. And I'm super thrilled to have her here. And last but not least is Erinn Contreras. She is our wonderful moderator for today. She is a partner at Sheppard Mullin, for Hampton's LP's business trial practice group in the firm's San Francisco office, and leader of the firm's multifamily housing team and Chambers Run construction team. She is a seasoned construction and real estate attorney who represents owners, developers, and investors in all stages of construction projects. She also is a wonderful UCLA alumna, and she proudly serves on the board of the UCLA Law Women Lead. So please give them a hand. We're super thrilled about this voting rights panel.
Kick us off?
Sure. Well, it's great to be with you. Great to be back home. I was just saying that I took federal courts with Professor Karst in this room in 1990. So a little weird to be back. It's my first time, I think, in this room since 1990. So. And the room hasn't changed other than the kind of projector. So I'm going to spend about 8 to 10 minutes just talking generally about the state of federal voting rights protections today, and then turn it over to Sonni. There are lots of provisions in the Constitution and in federal law that protect voting rights. You can think of the 15th Amendment that bars racial discrimination in voting, the 19th Amendment that bars gender discrimination in voting, the 26th Amendment that prevents age discrimination between 18 and 21 in voting. There's also the National Voter Registration Act, which provides certain protections, for example, from voters being purged from voter rolls in the 90-day period before an election. We're seeing some of that stuff coming up now. But I want to focus on the three biggest tools that voting rights lawyers have used over the last, say, 30 years to try to protect voting rights, and how the Supreme Court has weakened or killed all of them, and is about to do even more damage. So the first of the three protections is in the Constitution's 14th Amendment Equal Protection Clause. Right? Suppose that you're a poor voter and you don't have the money to get a photo ID. Photo ID might be free, but it's going to cost you a certain amount of money to get a birth certificate, and you may have some issues trying to get that birth certificate, especially if it's from another state, and providing the documentation to get that birth certificate. So challenges have been brought under the Equal Protection Clause saying, you know, I'm poor, I'm being treated worse than someone who's rich, who will have an easier time voting, and these voter ID laws don't really prevent a lot of fraud. And there were some challenges along these lines. Some of them were successful, some of them weren't, until the Supreme Court addressed this issue in 2008. So in the 2008 case out of Indiana called Crawford versus Marion County Election Board, The Supreme Court basically said, if you are challenging a voting law, like a voter ID law, you have to show that it's burdensome for everybody in order to bring what's called a facial challenge, to get the law thrown out. Otherwise, you have to bring individualized challenges, maybe class actions, and show that particular groups of people are burdened. And you as a plaintiff have to show that you face a severe burden. If it's not a severe burden, then the state can come up with its interests. And when we as a court are doing the balancing under the Equal Protection Clause and looking at the state's interests, the state doesn't actually have to prove their interests. The state can just say fraud is a potential problem, even though in that Crawford case, the state of Indiana could not point to a single instance of fraud in its history where someone impersonated someone else at the polling place. The upshot of Crawford is that it's really hard on plaintiffs to bring these suits. You can't bring them as suits for everyone. You have to find particular groups of plaintiffs. And the burden is such that plaintiffs have a heavy burden and the state has no burden. The state can just say, oh, it's going to hurt voter confidence if people don't have ID. They don't have to prove that, when in fact the best social science tells us that states with voter ID laws don't have people with more confidence. In fact, they have people with less confidence because people are fighting over voting rules. Okay, so one of the three pillars of key voting rights litigation was really made difficult in 2008 in the Crawford case. The second pillar is Section 5 of the Voting Rights Act. So the Voting Rights Act was passed in 1965, had a bunch of different provisions. It allowed federal registrars to go down and register voters. It banned literacy tests, did all kinds of different things. But one of the key provisions in 1965 is it said states with a history of racial discrimination in voting, they can't make any changes in their voting rules without proving that those changes would not make minority voters worse off. And to put the burden on the state to do that, the states that were picked were states that had low voter turnout and had a test or device for voting, like a literacy test or a poll tax. This covered much of the South, but eventually it covered a couple of counties in California, some counties in New York, parts of Michigan, Arizona, as the law was amended. The law was repeatedly challenged. The benefit of this law is that it put the onus on the states to show they were not discriminating, rather than putting the burden on plaintiffs. And the rationale behind this was every time the federal government had come in before and found a discriminatory voting law, the state would give up, and then they'd pass a new discriminatory voting law. So in order to reverse that burden of proof, they came up with this. The Supreme Court repeatedly said this was a permissible exercise of congressional power to enforce the 14th and 15th Amendments. Congress has explicitly given the power in these amendments to enforce it. Section 5 of the 14th Amendment, Section 2 of the 15th Amendment. And the court repeatedly rejected challenges until the case of Shelby County versus Holder, which you probably all heard about, 2013. The Supreme Court said the states that are being picked out, this is based on old data from the 1960s and 70s. The formula has not been updated. The law is no longer constitutional because of something the Supreme Court called the equal sovereignty principle. It didn't tell us where in the Constitution this clause is, but the court said the coverage formula is unconstitutional. We're not saying Section 5 is unconstitutional, just to figure out which states are covered under Section 5 is unconstitutional. Congress, you can try again. And Congress has not gotten its act together to try again for reasons we can talk about. And so then this leaves the third and final key tool, which is Section 2 of the Voting Rights Act. When the Voting Rights Act was passed in 1965, Section 2 was not a big deal. It basically just restated the 15th Amendment. You can't discriminate on the basis of race in elections. In a case in 1980, the Supreme Court interpreted that to require proof of intentional discrimination. So you have to show, oh, the reason these districts were drawn this way was because you intended to suppress minority voting. Congress came back in 1982 and said, this is not what we meant. The Reagan administration didn't like this law. The point person fighting against it was someone named John Roberts, who then goes on to become the Chief Justice of the Supreme Court. But Congress comes through, they compromise, and they say, all right, well, minority voters have less opportunity to participate in the political process and to elect representatives of their choice. That is a violation of the Voting Rights Act. And this law has been very effective in causing the creation of what we call majority, minority, or minority opportunity districts. There are many more representatives today who are supported by voters of color than there ever were before the passage of the 1982 Amendment. It applies to congressional districts. It applies to state districts and local districts. In 1986, the Supreme Court decided a case called Thornburg versus Jingles, and it said, this is some murky language in Section 2. Here's a 3-part test followed by an 11-part totality of the circumstances test. You're not in my class, you don't have to worry about it. But the bottom line is, plaintiffs have been able to navigate this. Not always, but they've been fairly successful. Until what's coming on Tuesday, which is a case called Milligan versus Merrill, in which Alabama says when you interpret the Voting Rights Act, you have to interpret it in a race-neutral way. And you only have to draw majority-minority districts when, if using race-neutral criteria, you would have had to do so anyway. It's a test that, if adopted, would turn the Voting Rights Act on its head and would lead to a huge decline in minority voter representation. One last point, and then I'll turn over to Sonni. Section 2 of the Voting Rights Act is not only about redistricting. It just says any voting procedure that makes it harder for minority voters to participate in the political process on the same way as majority white voters can be subject to challenge. So what about these voter ID laws and other laws that, for example, there was a law in Kansas and in Arizona that said you want to vote, you want to register to vote, you have to show proof of citizenship. You have to find your birth certificate. I mean, how many of us have our birth certificates when we're in front of Walmart, just trying to sign up to register to vote, right? There were a number of cases up until last summer where courts found that Section 2 was violated by by these restrictive voting laws. And you couldn't exactly apply that 3-part test followed by the 11-part test because that was really drawn for redistricting, but courts had come up with a pretty good test. And in fact, the Fifth Circuit, the United States Court of Appeals for the Fifth Circuit, the most conservative court in the country, found that en banc found that Texas voter ID law violated Section 2 of the Voting Rights Act. Until Brnovich came out in July, terrible decision. Justice Alito, it's the conservatives versus the liberals, the Republican appointed justices versus the Democratic appointed justices, saying that here's a new test for Section 2, and just like the court did in Crawford, where they put the thumb on the scale to favor the state, the court came up with a very favorable test. And among the things that Justice Alito said, which have no bearing to the text of Section 2 or its history, is if something was done in 1982, when Congress renewed the Voting Rights Act and changed Section 2, and that was okay, like making it really hard to register to vote was okay in 1982, then it's okay today. It doesn't violate Section 2. And so Section 2 has already been sapped of its vitality by, outside the redistricting context, by the Brnovich case, and what the court's likely to do in the case that they're hearing on Tuesday when the court's term is opening next week, Merrill versus Milligan, they're likely to further weaken Section 2 in the redistricting context. So that means the 3 main things that are done to help protect voting rights, they're all either killed or under severe attack by the Supreme Court. And Congress tried to pass the John Lewis Voting Rights Amendment Act, which would have fixed some of this, at least in the context of statutory fixing it. Can't really fix the equal protection problem without changing the Supreme Court or amending the Constitution. And mostly divided on party lines. The Voting Rights Act, which passed with large bipartisan majorities as recently as 2006, where in the Senate it passed 98-0, has now become another partisan issue. And there was virtually no support on the Republican side for the John Lewis Voting Rights Advancement Act. It's not going to pass this Congress, and if Republicans take control of the House and or the Senate, there's no chance at all it's going to be taken up in the next few years. And with that, on that happy note.
Well, I was going to ask, do folks want to hear some happy thoughts, or do we want to talk more about some? I can finish with the happy or end with the happy. I'll finish with the happy, or something to look forward to. So, what Rick was talking about, really these types of cases, we call them vote dilution cases. That's redistricting cases, and not just redistricting. I was talking earlier with Rick about at-large, a lot of local governments use an at-large method of election. So there's 5 seats on the county commission, and everyone in the county gets to vote. We know that those types of at-large methods of election can have vote dilution, result in vote dilution for minority populations that are not 50% of the citizen voting age population of the jurisdiction. We also have some vote denial. We were talking about vote denial with Brnovich. I'm very lucky. I have cases that are both going to be affected by Bronovich and affected by Merrill. So it's a really, I guess, a happy time for litigating. What I do with the UCLA Voting Rights Project, there's actually a clinic that's taught in the law school. It's part of the project. Is I take student-like cases, cases that students have developed over a year, 2 years with us, and I go file them. And I work with students. We work with co-counsel, so we work with law firms. We work with the Campaign Legal Center, MALDEF, ACLU, and local affiliates to go work on behalf of voters. 2 cases that were mentioned in my introduction is this case called Soto Palmer versus Hobbs. It is my only statewide case. I primarily do local cases. So my bread and butter is county, city council, and school board. The reason why is there are very little cases and organizations that want to do these cases, not because they're not important, but because they're unbelievably expensive. They can be very dangerous. There's a lot of vitriol that people have. In a case that was also mentioned in my introduction called Portugal versus Franklin County. It is the second case under the Washington Voting Rights Act. There are 3 county commissioners in Franklin County. Franklin County is in Washington state. It is over 50% total population Latino, 37% Latino citizen voting age population. The county uses an at-large method of election, or did. We actually settled the case. But in terms of just why these cases are unappealing or they can be dangerous, there was a county commissioner named Clint Didier, who was a former NFL player, and he ruled that county with an iron fist. He would say incredibly racist things during public county commission meetings about our clients and about the Latino population. He would fundraise and have threatening messages on his Facebook about this case. And so that's a little bit of like a taste of what happens in these counties. I know that our legal director, Chad Dunn, has actually been run off the road in some Texas counties that he's done voting rights work in. And that is to say that it is important and interesting work, but it is very granular work. But we know that when the county changes and when the school board changes, these changes are almost immediate. People go from having 0 members in their school board to having 2 or 3, and now their children, who are usually minority children, who are now have access to resources that they wouldn't have. That's not to say that statewide cases aren't important, but I find also the local cases are not as political. It's really more racist than anything because it's a little closer to home. So in Soto Palmer versus Hobbs, which is a statewide case, which will be directly impacted because it is a Section 2 case about whether or not Washington State had to draw a Latino majority district in the Yakima Valley region, which is southwest or southeastern Washington. And we're waiting to see what happens. There's also an intentional discrimination claim happening in that case as well. So really the work that I do is, I do day-to-day litigation with one of my co-counsel, and we work on behalf of Latino voters. I have a case in San Juan County, New Mexico on behalf of Native American voters. In that case, those voters, it's county level redistricting. They packed 80% of the Navajo Nation into one district, and then they supermajority packed it, basically. They made sure that the Navajo Nation voters or Navajo voters could not elect candidates of choice in any other district except this one. We're fighting to get them 2 districts on this county commission. Again, not about politics. It's not going to flip the control of the county commission, but we went out there, and the resources that folks get, there are places in the county in District 2 where Navajo voters live, where we're suing to get a Navajo representative of choice or an Navajo Opportunity District. There's a post office that burned down 4 years ago, and no one has built it back. So they don't have Navajo voters in that district. They can't recycle it in that district. They moved the recycling or the trash, facility outside the district, like 80 miles away in the county. And so these cases have some tangible aspect to them. People's lives are so directly affected by what their county and city and state governments do, so that when you do local cases, again, as I said before, like the impact almost feels immediate because people are finally able to have at least one voice on their county government. In that Merrill case, the UCLA Voting Rights Project wrote an amicus brief on behalf of social scientists on why Section 2 needed to stay, that racially polarized voting, which is, Rick did you guys a really nice favor by not having to explain the jingles test and racially polarized voting. If you want to learn about that, you could take Rick's class. But why, when there's the existence of racially polarized voting in these jurisdictions, it usually is coupled with racist actions and racist effect in all these different areas of their lives. And I also have a vote denial case, actually, and it's not on ID. It's actually, there are counties in Washington State. I've gotten really, really close with Washington State, where they're flagging Latino ballots at higher rates than non-Latino ballots. So Washington is an all-male voting state. It transitioned to all-male voting in 2013. And since then, Latinos in jurisdictions that have high Latino, so counties that have high Latino populations flag their ballots at higher rates. And it's not just if you have a Latino surname. If your name is Carl Garcia, you have a 50% chance of getting your ballot flagged. But if you're Carlos Garcia, you have an even higher chance of getting your ballot flagged. Our judge, Salvador Mendoza, in our case, who's now on the Ninth Circuit, recused himself from our case when he got assigned to it because he himself had his ballot flagged in the 2020 election in Yakima County. And in that case, we have to deal with the Bronovich standards. I don't know how they're going to fit in on 1982 because we didn't have mail voting really then, so it'll be very interesting. But we get to work with our social scientists and our experts on how to show intentional discrimination. Well, we're thinking at the UCLA Voting Rights Project, and I'm not sure if Rick, you're thinking this way too, is that a lot of our voting rights cases now are going to have to be showing intentional discrimination in so many aspects, more so than we had to with the effects. And it is hard to go in a community and for anyone, especially for plaintiffs though, to say that you're doing intentional discrimination. A lot of times your plaintiffs don't even want to say that because they know people in their community and it is a hard pill to swallow.
I have a question about what you just said about Judge Mendoza. Why would that precipitate recusal?
Literally don't know.
That doesn't seem like a ground for recusal because any judge who's a registered voter could or could not be impacted by that. Some ballots are going to be selected and not. I'm just curious because that seems like actually kind of a dangerous precedent to set. Yeah, we don't know. He just, the day after our scheduling order was signed, decided to recuse himself, and he didn't give a reason. I'm not sure if maybe it's because he didn't want to have this case when he went to the Ninth Circuit or what was happening there, but not entirely sure. I could not tell you. I was floored when that happened because it, again... I mean, I know they don't have to give the justification, they can just do it, but if you're surmising that's why, that seems strange to me. That's what he said. He said, I had my ballot flagged in 2020 and I'm going to recuse myself.
Well, the standard is one of creating an appearance of impropriety, and he might have thought that people might not have respected his opinion, given his history, even though he could be fair about it.
It's kind of like the Prop 8 judge. When people found out that he was gay, they made a big stink about, you should have recused, and I'm so glad he did not recuse. I'm with you, it's like, we're gonna just keep recusing until we get a conservative judge who's gonna really get us.
Yeah, I find that our the folks that we think are gonna rule for us make it really, really difficult for us.
So the intent of this panel is certainly to have an open dialogue, so thank you for your question. I would love to open it up now to others' questions if you have them, or of course I have my own questions. And maybe a word about me, I have no experience whatsoever in voting rights, but I'm on the board of LEAD, and when this issue was brought up as one of extreme importance that we wanted to have a panel on, I, like many of you, said I want to be involved in this panel because I want to know what I can do as a lawyer, as a person, as a mother, as someone who believes in the fundamental sanctity of voting to help protect voting rights. So I would love to hear from both of you on how we as lawyers, soon-to-be lawyers, just people can help. What can we do?
Well, one thing that lots of lawyers do is they go and do election protection work. So there's There's an organization that does election protection. It's kind of a consortium of different lawyers organizations. It's the Lawyers Committee and Leadership Conference and the NAACP Legal Defense Fund. It's a whole group of, and you could go to Arizona. You can go to Nevada. I mean, there are places that are close by. If you're in California, you don't have to go all that far. There are lots of volunteer opportunities there. There's also
What are they called? I'm sorry.
if you just Election Protection Coalition, it's 1-866-OUR-VOTE, OUR vote. I think it's one. I think if you do 866OurVote.com, it's really very easy to find.
Okay.
But it's a consortium, and so lawyers can work there. Two friends of mine started something called the Election Officials Defense Network in DC. This is Bob Bauer, who used to be White House counsel, was Obama's lawyer, and Ben Ginsberg, who was Mitt Romney and John McCain's lawyer. They're defending election officials who are being sued or who are being harassed. They're based in DC, and they're looking for lawyers. It's really particularly for legal work. Those are areas where it's possible to volunteer. And of course, through political parties, you can also serve as a poll worker. One of the things that, this panel is really about, I call it voter suppression. One of my big issues right now is election subversion, attempts to steal elections, which is a somewhat different topic. On that topic, I'm very concerned about insider threats now. People who are running elections not doing so correctly. So in addition to advocating for transparency rules, it would be good to have people who are actually working in polling places. And I'd like to encourage my law students to do that, but you can do that too. It's a few days, a few hours of training over a few days, and then a long 16-hour day on election day. But being in these places makes a difference. And there are problems with voting in California. It's just because it's California and you think, voting is easy here. It's not easy for everyone. And, there are things that can be done here too.
I would say, and this is kind of on a more happier note, states have the right to pass their own state-level voting rights acts. California has one, Washington has one, New York has one. And so pushing and advocating for a state-level cause of action for vote denial and vote dilution is going to be incredibly important in the next few years to provide more robust protections. I think that we talk about federalism, we talk about states' rights, and it's always been used kind of against, I think, voting and against protections. And while I would love to see robust federal protections, especially because those are endowed or should be endowed in the federal constitution, I would say that it seems like the best avenue nowadays is to go the state level route. You can make voting better and you can make it safer and you can provide protection especially for minority voters who we know are always the ones who are most affected when there are changes to voting laws by advocating for state level voting rights acts. I will also say that UCLA law students do have off on election day, so they should become poll workers. And the reason why I know that is because when I was a student here, I badgered the administration so many times to ask them to have off on election day so students can go be poll workers. So you should take advantage of that and do all the things that Rick said.
And I should say that under the California Voting Rights Act, it's much easier to prove a violation than it is under the Federal Voting Rights Act. All you have to show is that there's an at-large voting system. So say there's 5 members of city council and all 5 are elected by everyone, that's an at-large system. And all you have to show is that, and that there's racially polarized voting. So whites prefer one candidate and maybe African-American voters or Latino voters or Native American voters prefer a different, then you've established a violation. So I'm a former student who's become very wealthy, going around sending letters to every school board and every city in California. And if they make a change to districting, I think he gets 30 grand, and then if they fight him, he gets a lot more. The problem with state level voting rights acts is there is no Alabama voting rights act.
Oh yeah, there are no.
So in the places that need it the most, you're not going to get state protection. It's federal protection or nothing.
Yeah.
And proof of intentional discrimination, is really hard, even places like Alabama, because people are much more circumspect in what they say. I mean, you'd be surprised at some of the things that people will say or put in an email, but even when you can point to the rogue person, Justice Alito, who's been, killing the Voting Rights Act in 20 different ways, has said, we have to presume the legislature's acting in good faith. Oh, there's a few bad apples, you know, so it's really hard to prove intentional discrimination. Even when you have intentional discrimination on the record, that was only 1 or 2 legislators. The other ones were not infected by that.
And then you have the few bad apples on the Supreme Court. It is real bad. So you touched on this, and I would love to know more about the differences between the California Voting Rights Act and the Federal Voting Rights Act.
I think you can do it.
Well, so there are a few differences, and I think the major one is that the California Voting Rights Act, as Rick alluded to, is only regarding districts, so the vote dilution claims, you don't have a claim under the California Voting Rights Act for vote denial. So, and there's like a plethora of reasons why you want that. So let's say you live in a jurisdiction and they closed your polling location the day before the election, right? And there was only 2 or 3. So now you don't know where to go, you don't have adequate information. That's a vote denial claim in the wings waiting to happen. And so you could not bring a claim under the California Voting Rights Act for that. And again, the California Voting Rights Act is only about at-large to district-based elections. It's your former student, Kevin Shankman. Kevin Shankman has really solved the problem, I will say, of at-large jurisdictions in California. There are very few left. And if there are at-large jurisdictions, they're pretty diverse, so it's hard to prove racially polarized voting, or they might have very diverse elected officials. But in that instance, you know, California is a state where you can actually push for change. We can make more robust law. And I will say, as Rick said, there are voting rights violations in California. Kern County right now is getting sued for under the Fair Maps Act, which is a California state law on redistricting, because they intentionally, they drew their districts to break up and crack the Latino population into 3 different districts. So there's only 1 majority Latino district when there should have been 2. And California really has a long history of violations of Section 2 on the county level. So again, I think there is a difference. We always look at the state lawsuits and the state action for both vote denial and vote dilution are really interesting, and they're, I would say, like the more sexy topics, because people are like, why do you care about some random rural county in California? But if you guys didn't know this, Los Angeles County actually got sued in 1990 for intentional discrimination, again, for the way that they drew their Board of Commissioner districts. Because prior to 1990...
Supervisor.
Yeah, sorry. I call them commissioners, but yeah, the Board of Supervisor districts. And the reason why is because prior to 1990, Los Angeles did not have 1 Latino majority district. Even though it was, I think, about to become a Latino majority in total.
It was over 40% at the time.
Yeah, and Latinos had to sue. And it's not until 2021 when we now have 2 Latino majority supervisorial districts based off the map. And the only reason that probably occurred is because there's an independent redistricting commission for the county supervisor districts. So really, there are tons of issues in California not on county level, on the state level, county level, city level, and school board level, and those are, again, just as important.
Can I ask a quick question? We talked a lot about redistricting, but you know, one of the things I've heard people talk about is, you know, our voting days are Tuesdays.
Yeah.
Right? And so a lot of people trying to take off work, what are the thoughts of like moving our voting days to like a Sunday, right? And things like that. So to me, that's a huge...
I'm going to be a contrarian here and say
Okay.
that in California, you have at least 2 weeks to vote. You can vote early, in person or by mail. It's really not hard to vote in California. And yes, you might be busy on Tuesday, but probably not the Saturday and the Sunday. And if you're busy all of those times, everyone in California is being mailed a ballot.
With postage.
With postage paid, right. So, you know, I don't think it's so burdensome that election day is on Tuesday. Move it. I'm worried if you move it to a weekend, people are going to say, you know, make it a 3-day weekend. You know, it's like, well, now we have the day off. In Italy, they have mandatory voting, and it's like a week-long holiday, and they pay for people to go back to their hometowns to vote.
Wow.
Okay, I mean, that's a great civics thing, you know. In Australia, they have mandatory voting, and you're fined $50 if you don't vote. It's not really enforced, but people come out to vote. I'd much rather see mandatory voting than moving election day to Sunday. I don't think, and you know, we're going to have a midterm election coming up in about a month, And turnout is probably going to be the highest in a midterm election
Yeah.
since 1914. I don't think turnout is the problem overall. The problem is unequal turnout, and who is registered to vote. So a huge issue. I was just on a panel for the business trial lawyers dinner with Laura Brill, who runs something called the Civics Center. I encourage you to look it up. It's about youth voting, and the rates of voting by youth who are registered to vote are pretty high. They're pretty darn high. But getting young people registered to vote, those rates are abysmal in some places. She was working on Pennsylvania, like in Philadelphia, it's like 18% of people who just turned 18 were registered to vote. So you got to get people to register to vote. I mean, I think there are more pressing problems than voting on Tuesday, is my view.
So you all have said some terms, and I would like you to expand on them more. So we talked about vote dilution, election subversion, voter suppression. I'm sure there are others. And you live this day in and day out, but can we describe a bit those three buckets? And it feels like fires are burning everywhere. Should we be focusing our water on one, or which one do you think is most critical right now to our democracy?
Ooh, I think they're all critical. I will say, I think probably election subversion. I know I don't even do that work, but man, that is so scary. It's so scary that I don't even want to think about it, which is hard when you're a voting rights lawyer and you don't want to think about people stealing elections. And I think it's hard because there's very little that you as a lawyer can do. Part of it is up to voters to elect. A huge issue is that we elect the people who run our elections, and they are probably not qualified to do it, and there is a perverse incentive to, especially now, based off of, to make sure your side wins. That is the idea of it. And so when you elect, I think, folks to run your elections who want to win at all costs or believe, and I don't even think it's winning at all costs. I think they truly in their heart do not believe that the other side has support. That there's nothing, they cannot fathom that people support the side that they're not on. And the reason why is because everyone in their network is reinforcing them. They're saying, everyone I know is voting for this candidate, so how could it be that this other candidate won? And it's not even just a problem within like Democrats versus Republicans. You see Republicans who are really, I think, the party of election deniers right now, turning in on themselves and saying, this person didn't win and they're illegitimate. I don't know anyone who won, and they have, they've done something to falsify it. So that's, I'm with Rick here. I think it's election subversion.
Yeah, that is my main issue. And I just got here in July. I used to teach at UC Irvine, where I had a center with Professor David Kay, who used to teach here, some of you may know him, called the Fair Elections and Free Speech Center. Now I'm working on something called the Safeguarding Democracy Project, and it's focused only on this threat to free and fair elections in the United States. And I don't mean vote denial, like hard to get a voter ID, or vote dilution. People are in districts, they're able to vote, but they can't vote for they can't elect their candidate of choice. I mean that the winner of the election doesn't take office. I mean, something I never expected to worry about in the United States. I was thinking at this point in my career, I'd be going off with the Carter Center, we'd go to some new democracy, and we'd be observing, and then they would sample the local cuisine. Instead, we're worried about it here in the United States. Yeah. Congress is poised to actually pass bipartisan legislation that's going to make election subversion harder. It's actually a good news story. Congress didn't pass the John Lewis Act. It didn't pass the For the People Act or the Freedom to Vote Act, which were broad, prevent partisan gerrymandering, fix voting rights. But this law would make it harder to say, oh, the vice president, he can just decide which states votes to throw out. Or why doesn't the state legislature get to pick their own slate of electors after people have voted? Those kind of things would be made illegal by this reform of an 1887 law called the Electoral Count Act. So that could happen. I've been telling reporters I think that law is absolutely necessary, but it's insufficient to deal with the threat. There's other things we need to do. I'll name just two. One, in about 9%, according to the Brennan Center, 9% of Americans vote on voting machines that are wholly electronic. They don't produce a piece of paper. Can you imagine if Trump, as he did in Georgia, was able to say, yeah, it's in the machines, he claimed that Italian satellites had altar or bamboo from China in the ballots. I don't know if you heard any of these things, but if you don't have a piece of paper that a judge or other people can look at to verify the results, we're in a lot of trouble. I mean, that should be low-hanging fruit. Now, yesterday for the Safeguarding Democracy Project webinar series, we have an online webinar series. You can find them all online, safeguardingdemocracyproject.org. I interviewed Adam Schiff, the congressman from right here in Glendale, and I said, why isn't a paper ballot requirement in there? And it was in some of the Democrats' legislation. Said they do not have bipartisan agreement on that. So I mean, there used to be bipartisan agreement on that. The other thing that needs to happen, we need protection for election officials. I think something like 25% of election officials are going to have retired or been forced out between 2020 election and 2024. That creates a double threat for our democracy. Number one, the people without experience. The people with experience are gone, and elections going to be run by people without experience. The other thing is, if somebody comes in and says, either they believe or say they believe the last election was stolen, we have a crisis on the right now about believing elections are stolen. You tell me if Mark Fincham, who's a big election denier in Arizona, is running the election there in 2024, and he says Trump's won against Biden. People on the left going to believe him, even if he runs the election fairly? I don't think so. So we're going to have another crisis of confidence, and that's coming on the left. And so, we've got to do things to protect our election officials. And of course, we need transparency. We need lots of things we need. But that is, to me, this is the number one immediate threat facing democracy. I don't like voter IDs, and I think that actually favor a national voter ID and universal voter registration conducted by the government, but we're not getting there anytime soon. But I think the most urgent problem is assuring that we can continue to have the election winner actually take office.
Yeah. When is that legislation supposed to be heard or passed, do you think?
Well, they're talking about it in the lame duck session because Congress is the Senate is about to go on break until after the election because they all have to go and campaign, but in the lame duck. There are now 13 Republican co-sponsors and 13 Democratic co-sponsors in the Senate. You need 10 to break a filibuster, and Mitch McConnell is signed on. And he was not signed on to any of the other legislation. That's his hand in the back.
I'm curious that one of the strategies I haven't heard you articulate yet, what your thoughts are on it, is just regular enforcement of criminal laws that already apply. So for example, the investigations that are happening in Georgia now of people who attempted to subvert the election, who potentially broke the law. And so do we really need new legislation, or do we need real investigation by county DAs or state election officials or state criminal prosecutors to prosecute the people who are attempting on a large scale, or even on a conspiracy level, multiple states. Some of the actors in those were in multiple states trying to fiddle with voting machines. So the question is that part of the strategy too? Because it seems to me that also has some deterrent effect, but also a protective effect.
Sure, I think we need both. It's hard for me to believe that if Donald Trump is indicted in Georgia, in Fulton County, that this will get to a jury and that there will be 12 people on that jury who will vote to convict Donald Trump regardless of what the evidence shows. So I'm scared, and I don't know what Merrick Garland's going to do on the federal level. They've moved very slowly. Indicting a president is difficult. Now maybe Trump gets indicted on the classified documents first.
Yeah.
I don't know what's going to happen.
I'm talking about like the actors who went into buildings and who tamper with voting machines and who've actually...
Right, so those people who tamper with voting, who got access to software, yeah, those people could be prosecuted. I'd like to see the penalties greatly increased and the laws expanded for what counts as interfering with an election. I have a piece in the Harvard Law Review Forum. It's linked on electionlawblog.org on the right-hand side. It's called Identifying and Minimizing the Risk of Election Subversion in the Contemporary United States, and it's got a whole list at the end of all the kinds of changes to election laws that I think would be useful. Criminal law.
What do you think, I mean, with all these challenges in place, right, and with all the things that people can do as lawyers, but what do you think it would take for the public perception to change back to maybe where it was, right? Because there were probably always people who were thinking there were conspiracy, right? And that belief has become much more mainstream and much more in the minds of people. What would it take for us as a society to go back to a place where most people think the system works as it's intended, that it's reasonably fair, and that fraud and misdeeds are fringe and not really an issue?
I mean, you just need leadership. I think that there's, for a very long time, people have lost, and I think that it's across the spectrum, people have lost confidence in their government because it takes forever to do something. It's very incremental, the change, and for most people, they don't feel it. And we don't have leaders that act, like, it's attractive to lie because it's easy with, I think, the internet and the fact that just people now gravitate towards cults of personality for people to believe those lies even in the face of all evidence, because you can just say, okay, but that's what one person has said. There is no baseline fact, and because leaders have tapped into that, you know, we are heading towards, I think we're just heading towards this giant crisis of what is factual information, and the way out of that is to have leaders who do not kind of play into using widespread lies. Like if Donald Trump, for example, did not perpetuate the big lie and just took his loss gracefully, and like that, I'm not sure that would ever happen, right? I think it was Mark Meadows who wrote an op-ed though that he would, which was pretty funny. You know, if it would
Mick
be,
Mulvaney.
Oh, Mick, yeah.
The former
chief of staff wrote, you know, that I think it would have been harder. You would have still had all those fringe people saying those things, but we have to stop giving platforms to those people. And it's just hard when the biggest election denier is the person who probably will get nominated again for 2024.
So I think the problem goes well beyond Donald Trump, unfortunately.
Yeah.
I wrote a book that came out in March called Cheap Speech, How Disinformation Poisons Our
Yes.
Politics and How to Cure It. It's about this very topic.
Yeah.
And it's really hard to think about how to solve these problems when you have a commitment to both having free and fair elections, where people can have confidence in election results, and a commitment to free speech. You know, so can you just pass a law that says, oh, well, it's a crime to lie and say the last election was stolen? I think that'd be very hard to sustain with the First Amendment, in part because what if the next election is stolen? You want the candidate to be able to say that. You know, so I do think you could have narrow laws, like laws that make it a crime to lie about when, where, or how people vote. So we had a guy in 2016, Trump supporter, sent messages to African American voters telling them that they could vote by hashtag, social media hashtag, or by text, and 4,000 to 5,000 people tried to do this. And so he's now been indicted under a law that I don't think applies, but we could have a law that would apply. I think that we need to give voters better information, so they need to know, well, who's actually trying to influence me? Or like a deep fake, you know, they could be labeled as altered, but I think a lot of it is not going to come from law. It's going to come from us pressuring the platforms to do the right thing. It's going to come from employees of the platforms pressuring them to do the right thing. It's going to come from civic education, building up local journalism. Journalists have lost jobs in the last 2 decades faster than coal miners. We have news deserts. And they're replaced by propaganda from the Democratic Party, the Republican Party, Russian government. They all come in and purport to be local news, and you know, so it's a huge problem. It's the biggest social problem, and it's a problem around the world with disinformation. But it's been activated because people have both a financial and a political incentive to lie about and delegitimize elections. So that's what has paved the way for the election subversion, because there are many people who actually believe the lie. So if you're a poll worker and you see something and you just don't understand what's going on, you're immediately now going to think, oh, they're trying to cheat. And then maybe you're going to think, I'll cheat back. A lot of the people who voted twice in the 2020 election, and there are only very few of them, but a lot of them were Trump supporters who said, I'm trying to even the score.
We also don't really fund our election infrastructure, and that's a huge problem if you're not adequately funding for, elections are expensive to run, and it's expensive to hire staff to run those elections, and if we're not funding, and counties in states run elections. Individual counties do. So if we're not funding those county election officials adequately, if we're not buying new equipment, if we're not, if we're not investing in our election infrastructure, then it's also helpful. It's also, a big problem when it comes to misinformation.
Yeah, funny story about the 2020 election. We had a pandemic. I don't know if you guys remember. And people like the Brennan Center groups went to Congress and said, we need $4 billion more to be able to run our election safely. It's hard to run an election during the pandemic. You need space, you need PPE and all this stuff, and Congress didn't do anything. So guess who stepped up? Mark Zuckerberg came up with $300 million. And through a group in Chicago, they offered funding to local election administrators to help them defray the cost. Well, now Zuckerbucks is now the latest conspiracy. Mark Zuckerberg was trying to steal the election for Democrats, and I was just speaking at another university, and a conservative law professor said, what about those Zuckerbucks? Wasn't he only giving them to Democratic candidates? No, that's not actually how it went.
A professor was saying that?
A professor was saying
wow.
that. So, I have a lot of bad things to say about Mark Zuckerberg, but thank goodness we had that money, because the thing that would have been even worse is if the election would have been poorly run. And in fact, it was a well-run election in a pandemic, and we were very lucky about that.
Yeah. So the key takeaways for me are there are a bunch of organizations that we can go to and join that you've given us, and that maybe we can pull those resources and circulate to everybody on getting out there on election day, right? Being a poll watcher. I think as a partner at a big law firm, there's a lot of opportunity to partner with your organization on a pro bono basis and taking on cases. And the postcards to voters, I think, is a big one too, just getting out to vote, although it sounds like that's less of important. I think people are very strongly getting out to vote if they're registered. So this has been super enlightening. We thank you both so much for your time. Thank you all for coming and participating, and enjoy the rest of your day.
Thank you.
If you're a student at UCLA for law school, you guys can learn more about the UCLA Voting Rights Project. We always take summer fellows, we take during the school year fellows, and there is a clinic here. And also take Rick's class.
Spring.
I didn't get to take it because he wasn't teaching here then, but I feel like I really lost out. So.
You seem to have done okay for yourself.
I mostly put Nina Tolson to teach my election law class, so she was pretty great.
Oh, was she visiting you?
I begged them. I was like, can you please do so much?
Thank you so much, Rick. I really appreciate it.